Hello, everyone, and welcome to Faith in the Law, our podcast on religious freedom and religion in the public square, and the treatment of religion in the law. I'm joined here today by one of certainly my intellectual heroes and one of the greatest, or if actually I would have to say the greatest living scholar of religious liberty jurisprudence in the United States today. And he's certainly a towering figure. He really needs no introduction, but we're going to go ahead and introduce our guest. His name is Professor Douglas Laycock, and he has taught and written about religious liberty for more than 4 decades at the University of Chicago, the University of Texas, the University of Michigan, and the University of Virginia. He retired from teaching at UVA Law School in May 2023. This brief bio, which I'm reading from his website at UVA, actually really just scratches the surface. It's woefully inadequate here, but it mentions that he has testified frequently before Congress and has served and has argued many cases in the courts, including the U.S. Supreme Court, where he has served as lead counsel in 6 cases. And he has also filed very influential amicus briefs or friend of the court briefs, one of which we're going to discuss today. And he is the author and co-author in the most recent edition of the leading casebook, Modern American Remedies, and the award-winning monograph, The Death of the Irreparable Injury Rule, and many articles in leading law reviews. And for our purposes, he has written a 5-volume collection of works on religious liberty. So it's an extraordinarily storied career, and we're deeply honored and grateful to have Professor Laycock with us today. Professor Laycock, did I miss anything in any of those?
Well, I would just add that my view has always been that religious liberty is for everybody, and I have argued on behalf of conservative Christians and religious minorities and non-believers, and I think they're all entitled to protection and respect for their religious liberty.
And it's interesting that you mentioned that because you are quite different. If someone wanted to try to pin you down into this sort of traditional right-left political paradigm, it would be quite difficult. And I think that is a testimony to the fact that you are arguing on behalf of timeless principles that, frankly, supersede the traditional political spectrum that we're used to. So what we're here today to discuss is an extremely important case, and that is Mahmoud versus Taylor. So Mahmoud versus Taylor is a case that I have been actually personally involved with on the ground before it was ever a case that was filed in the courts. In this case, the Montgomery County Board of Education in Montgomery County, Maryland, introduced storybooks into its language arts program that were intended to teach children that and now my recitation of the facts here will certainly be disputed by Montgomery County. I'm trying to be as fair as possible and neutral in my discussion of the facts, but essentially these storybooks are intended to teach children that what happens when someone decides that they can change their gender, or when someone is involved in a sexual relationship between people of the same sex. Now, these books do not explicitly discuss sexual relations. They are not of those more kind of controversial books that are found in some school districts around the country, or that people have pointed to as being inappropriate for inclusion in public school libraries. These books are far more along the lines of sort of traditional storybooks, but these storybooks are intended to familiarize children with the idea that there are some people who believe that they can change their gender, and there are some families that include parents of the same sex, or that there are some children who are attracted to members of the same sex. And so Maryland state law permits parents now currently, there have been bills to try to change this. Maryland state law permits parents to exempt their children from sex education, explicit sex education instruction in health class. But what the district is doing here is arguing that this right to opt out under state law does not apply to these storybooks because they are part of the language arts curriculum. And so, a cynic might say that what they were attempting to do here was to do an end run around the exemption that is allowed by law in sex education classes and introduce this material into language arts as a way of circumventing that. I don't know if that was their intent or not, but that's certainly the effect. So Muslim and Christian parents, primarily immigrants, sued in federal court, arguing that Montgomery County Board of Education is violating their constitutional rights to religious freedom under the First Amendment Establishment Clause, Free Exercise Clause, and also under the 14th Amendment, namely their right to direct the upbringing of their children. Essentially, the argument is that the school district is intending to alter their children's views of these very contentious issues, which the parents are arguing is their right to handle when it comes to teaching their children about such matters. So the district court denied the parents' motion for a restraining order and held that parents really have no right to exempt their children from curricula. Now, the parents appealed to the U.S. Court of Appeals for the Fourth Circuit. The Fourth Circuit upheld the denial of the temporary restraining order, but on a slightly different, taking a slightly different position. The Fourth Circuit said that, well, if these facts are all that are alleged in the complaint are all true, then perhaps this would amount to a violation of the parents' free exercise and parental rights. But the parents have not shown that any child has actually been coerced or there's been an attempt at coercion. They're merely saying that this policy allows teachers to ask certain questions or to probe in a certain direction, but it does not require them to do that, and so therefore they have not shown the requisite injury in order to obtain a temporary restraining order. And so the parents appealed to the Supreme Court, and the Supreme Court agreed to hear the case, and the oral argument in the case will be April 22nd. So Professor Laycock, the question presented in this case is, do public schools burden parents' religious exercise when they compel elementary school children to participate in instruction on gender and sexuality against their parents' religious convictions without notice or opportunity to opt out? I wanted to tee off our discussion here by asking, could you lay out the legal context of the issues involved here? I mean, there's the question presented here is framed as a free exercise question, but there's also a sort of underlying, and they didn't really press this, here in the Supreme Court as they did in the courts below, but there's also a 14th Amendment parental rights. There's also, to what extent is there overlap between, is there a hybrid right here? Could you lay out the context of the legal questions involved here?
Well, I think they are arguing both parental rights and free exercise, maybe with more emphasis on free exercise. But the two legal theories are heavily overlapping because the most common reason that parents offer for wanting to opt their children out of some form of instruction is a religious reason. It's not the only reason, but it's the most common. So the parental rights argument goes back to, in the Supreme Court, goes back to a case in 1923. and then another in 1925. In the wake of World War I, and in the wake of the huge flow of immigration around the turn of the 20th century, there's a lot of hostility to immigrants, as there is now, there was then. And Nebraska made it illegal to teach foreign languages to children under a certain age. I forget what the age was. And that was challenged by a teacher in a private school who was teaching German. And the court struck down the Nebraska law and said, children are not the creatures of the state. Their parents have a right and a responsibility for their education. If they want to teach their kid a foreign language, they can do that. And then 2 years later, in a case called Pierce versus Society of Sisters, Oregon had actually passed a law requiring all children to attend public school. So the effect was to shut down all private schools. It hadn't taken effect yet. It was going to take effect in another year or two. And the court unanimously struck that down and said, again, parents have a right to control the education of their children. And then there's a third case, much less well known, also from the 1920s, called Tokushige versus Farrington, that said, state, all these cases that states can regulate private schools, required they teach the core curriculum and have accreditation standards and so forth. But Tokushige involved a Japanese language school in Hawaii, and the court said, but you can't regulate them so stringently or intensively that they become indistinguishable from a public school. You've got to allow some autonomy to these private schools. So there was this flurry of cases in the 1920s, and then, not much development of that, not much happened for a long time. One more case that is central to the argument in Mahmoud versus Taylor is Wisconsin versus Yoder in 1972. And this involved an Amish community in Wisconsin. They sent their children to public school through 8th grade. But the district was nearly entirely Amish, so it was culturally comfortable, I think, for them. And then they refused to send their children to high school, and they said, we're giving them vocational education on the farm. And if we sent them to the big centralized public high school, they'd be tempted and drawn away from the community and from the Amish faith of their parents. I think it was 7-2, the court said you can't require these kids to go to high school. Remarkably little has come of Wisconsin versus Yoder in the ensuing 50 years. There's been lots of litigation in the lower courts. This is the first time the Supreme Court has looked at this issue since 1972. And the line that has been drawn in the lower courts is, you have a right to opt out of public school. You can go to private school under those cases in the 20s. If you're Amish, maybe you don't have to go to school at all, or you can have homeschool. There has been a big development of homeschooling, not mostly politically, not through litigation. But if you come into the public school, it's all or nothing. You have to take our whole curriculum. You can't opt out. Most states legislatively let you opt out of sex education. And as you mentioned, there's this issue here. Is this really sex education, or is it just language arts? If you look at the books, it's obviously sex education. So it seems to me. It takes a very narrow definition of what counts as sex education for this not to count. At least some states let parents opt out of anything. Texas has a statute since the 1990s. You can opt out of anything. There's been no litigation under it that I'm aware of. My next door neighbor is the general counsel to the Texas Association of School Boards. This is not a problem. Maybe in part that's because people don't know about it. Doesn't have the publicity of a Supreme Court decision, but most parents don't opt out frivolously. They want their kid to be educated. But there have been repeated efforts through litigation to opt out of certain kinds of things, and the school boards have bitterly resisted that. And the story they have sold to all the lower courts is it's just not workable. There'd be too many opt-outs. The curriculum is an integrated whole. Every part of it is connected to every other part. That may be some theoretical educational ideal, but it's not how any of us remember public school, I don't think. And but because it's an integrated whole, the kid opts out of one part, he's going to have trouble in another part. We can't provide alternate lessons for these other people, for all these opt-out kids. One of the better known cases from Tennessee, the parents didn't even ask for an alternate assignment. They said, we'll fill in the gaps at home. No, that's not workable either. And they have sold this to the lower court. So the status quo has been there's a right under the Constitution to private schools. There's a right if you're in an isolated, secluded community like the Amish to maybe opt out entirely. And legislatively, there's a right to homeschool, but there is no right to pick and choose and opt out of parts of the curriculum once you go to public school. That's what is fundamentally at issue in the Supreme Court, and on facts that are pretty appealing from the perspective of the parents, right? If you can opt out anything, it has always been sex education. And what's being taught here is highly controversial, touches on fundamental values of some of these objecting parents. So it's a pretty appealing case for an opt-out, and the court has been very supportive of free exercise rights in recent years. So it's a tough case for the school board to be arguing in this court.
So typically, the Supreme Court will agree. I mean, it agrees to hear a minuscule number of cases that are appealed to it. In this case, what do you think that the court? Why do you think that they took this case? I mean, normally they don't take cases just because they see that the Court of Appeals made a mistake. Typically, they'll take cases, in order to correct what they see as a circuit split or some really fundamental issue in jurisprudence. Why do you think they took this case? What are they trying to clarify?
I think they took this case because they thought the issue was important and they didn't need to wait for a circuit split. And I don't recall the petition for the court to hear the case in any detail, but if they looked at the history that I just summarized very briefly, would see ever since Wisconsin versus Yoder, we've been litigating this issue for 50 years and no circuit split has emerged.
No.
The courts of appeals are all ruling for the school boards, and at least 4 of them, it takes 4 to grant a petition to hear a case. My guess is more than 4 thought that was wrong, thought this was a pretty important issue and it deserved their attention. They do from time to time take cases without a circuit split and reverse what has been the unanimous view of the Court of Appeals. And as I mentioned, I think especially to the conservatives, but maybe even to some of the liberals, the facts were pretty appealing. This is a pretty extreme policy that is being enforced in the Montgomery County schools.
You mentioned that the primary argument of schools in these type of cases, and there have been a number of cases like this in circuits around the country. Their primary argument is essentially a practical one that essentially that if they were going to grant an opt-out to these parents, and they would have to grant opt-outs in all kinds of other cases, and actually specifically in this case, the Montgomery County had initially allowed parents to opt out of these storybooks, but then they just received so many opt-out requests that they said this is not workable. And number one, they said it's not practical because then they would have to develop some alternative study program for all the opt-out kids. And then on the other hand, they said also it would kind of be a dignitary harm, as it were, for those kids who, whose circumstances were reflected in those books, and they would feel bad that kids didn't want to read about their families and so on. So it seems to me that if there's a, if we presume that the standard here is strict scrutiny, and that the government, the government interest, to override, a free exercise claim has to be of the highest order. It seems to me that to argue that, well, it's just going to be practically difficult for us to, to create an alternative, study program for those who are opting out, and it's going to hurt the feelings of these kids. That, okay, both of those might be actual legitimate concerns, but it seems hard to argue that those things override, the free exercise rights of the parents here. Is that fair to say?
Well, you got two very different interests being alleged. Administrative convenience has never been a compelling government interest that overrides a constitutional right. I don't know how they teach reading in Montgomery County. It seems to me unlikely that this is the entire reading curriculum, right? There are already other books being used.
Yeah.
And once the kid has the basics of reading, it's not difficult to find other age appropriate books and telling you read this while we're talking about this other thing. It's obviously easier for the teachers if everybody's reading the same thing at the same time, but it's not so wholly unworkable as to be a compelling government interest. The other issue is another thing that's been kicking around the lower courts for a long time. How does dignitary harm to sexual minorities relate to the free exercise or parental rights of other families? The dignitary harm is real. I don't dispute that.
Mm-hmm.
But you cannot have a right to be sheltered from the fact that some people disagree with you. And that's very well and long settled in free speech cases. The government cannot censor speech because it is going to be offensive to somebody. And they've held that in all sorts of contexts. They've held it about the F word. They've held it about extreme political views on one end or the other.
303 Creative is an interesting one, right? Where, yeah, the court said, well, this definitely is a government interest that people's, dignity not be harmed, that their feelings not to be hurt. And I don't say feelings hurt to minimize that, because that's a significant thing, but when someone who is having a same-sex wedding, and they go and they ask a website designer to design something for them, and the website designer says, well, I just can't do it because of my faith. I believe that marriage is between a man and a woman, that the government may have some interest in preventing the hurt feelings there, but that interest doesn't override the constitutional rights that would be impinged. Is that kind of a similar thing here?
Yeah, that's the argument, but the argument's both broader and deeper than that. So we've got this settled rule about offensive speech, and the blue state governments and the gay rights movement have resisted extending that to religious free exercise. And really the core of the argument, the core of their intuition is this: we're no longer talking about speech, we're talking about conduct. And conduct has always been much more regulatable than speech. And back in the 60s, in the desegregation era, courts said you don't get a religious exemption from serving African Americans.
Mm-hmm.
Well, there really was a compelling interest there, right? If they'd allowed an exemption in the Deep South in the 1960s, the whole white population would have opted out. Not because they were all racist, but because so many of them were, there would have been intense social pressure on the others. So they've got those precedents. We're not in the same situation with respect to gays today, or even transgender. There's a lot of hostility, but it's nothing remotely like nearly unanimous. And we don't have the same constitutional history. However badly we've treated gays, and it's been very badly. They were not held in slavery for 250 years, right? It did not take a civil war and 700,000 deaths to begin addressing the problem. There hasn't been, from the time we began addressing it, there wasn't another 100 years of Jim Crow before we made any progress. I think race is constitutionally unique in our history. That is a highly controversial proposition, rejected out of hand by, I'm sure, by the Montgomery County School Board and by all the gay rights organizations. But it's a real difference. So what we have is it's refusing to assist with a same-sex wedding or opting your kid out of an offensive reading or reading that you find offensive. That's not just speech, that's conduct, but it's constitutionally protected conduct protected in the First Amendment to the same extent as, or in a very similar way anyway, as speech. And the harm is the same, right? People are offended when you exercise your right to opt out. Well, it's not enough to override speech, and it shouldn't be enough to override the exercise of religion either. But that is in itself another controversial proposition that is teed up as an issue in this case.
Yeah, thank you. I mean, it seems that the aim of Congress in, for example, Title II of the 1964 Civil Rights Act, prohibiting discrimination in public accommodation. I mean, they're trying to unwind Jim Crow. Essentially, they're the remnants of Jim Crow. Whereas, with the things like gay rights and that sort of thing, you're just dealing with, you're not dealing with the same sort of like structural, deep-seated, issues involved. And for example, if like in other words, like not all protected classes are protected in the same way or for the same reasons or weight is similarly weighty. I mean, if a store said, "Oh, I'm not going to serve you because you've got red hair or because you've got blue eyes or you're left-handed or something like that," would seem to be different than, "Well, we're not going to serve you because you're black." That would just seem to be of a different the government interest there in preventing those sort of that sort of discrimination just seems to be different.
This set, of course, is extremely controversial.
Yes. Has any court ever? I I I I kind of think. I mean, I mentioned 303 Creative, and there was this interesting line in there where the court, it was the majority opinion, said something like that. If I can find it while we're talking, I'll read it to you and tell me if I'm if I'm kind of off base in the way that I read it. They didn't explicitly say that, but they did kind of say, well, the government interest here in dignitary harm does not override. I feel like they would not have said that if it had been a Title II case, where race was the was at issue, as opposed to. But I don't know. I'll find it while we're talking and see if maybe if I can find it.
You're probably right about that. Another way to think about this is dignitary harm on both sides, right? One side is insulted or offended with respect to its sexual orientation or gender identity. It's their choice of vendors for their wedding is very slightly contracted. The other suffers dignitary harm from being forced to violate their deep religious commitments. In the It's not so true in Mahmoud, but in the wedding vendor cases, the weight of that harm is clearly much greater on the religious side because they're in the business of doing this all the time. So the wedding baker in Denver who wouldn't do same-sex wedding cakes
Mhm.
has to either surrender his conscience permanently and agree to do them for anyone who asks, or surrender a big chunk of his business, and that's also permanent. Whereas for the couple, if all goes well, it's a one-time event. They're only going to get married once, and at worst, they're going to get married 2 or 3 times.
Right.
So you've got a serious but temporary harm on one side and a serious but permanent harm on the other side. Yeah, that analysis isn't quite so clear as applied to the storybooks in Mahmoud, but you
Mhm.
do have dignitary harm on both sides.
Well, definitely, Montgomery County is claiming that their interest here includes protecting the feelings of the kids whose feelings there, I guess, would presumably be hurt if people opted out of learning about families like theirs. So it does seem. Now, let me ask you this. You mentioned in your brief, and did want to ask you about your brief that you filed in the merits stage of this Mahmoud versus Taylor here. But one of the things that you argue is that Yoder applies here, and the Fourth Circuit kind of agreed with Montgomery County that Yoder doesn't really apply. Yoder, the Supreme Court has kind of seems to have restricted or limited Yoder to saying, oh, well, this really kind of applies to the Amish, or at least that's how the Fourth Circuit saw it. But you've got many other cases. For example, in this case, you've got Muslim and Christian immigrant parents who, these folks take their religion quite serious. I mean, the court seemed to say below, or at least even arguably the Supreme Court has said in other cases discussing Yoder that really it's only Amish people who care very deeply about their religion, and that seems to be just empirically incorrect. You've got for that matter, you've got Orthodox Jewish parents and institutions in New York right now battling New York State over their attempt to kind of impose themselves in or interpose themselves into yeshiva education, which is another case that seems like it might make its way to the Supreme Court. It's in the New York State courts right now. So, do you argue in your brief, or do you address this notion that Yoder somehow really only applies to the Amish?
Yeah, we do, and I don't think you quite captured the argument that it's only the Amish. It's not that they're the ones who care the most.
Mm-hmm.
And again, this is all in the lower courts. The Supreme Court has not taken another one of these cases since Yoder.
Okay.
But the argument has been the Amish are unique because they're withdrawn from the larger society.
Mm-hmm.
And if they don't learn some stuff, no big deal, because they're only going to be dealing with each other anyway. And if you're not, and another key factor about Yoder, it's often overlooked. Wisconsin only required mandatory education through age 16, which is roughly 10th grade or so. On average, is about another year and a half more than what the Amish were willing to accept. And so they had a great difficulty showing a compelling interest in that incremental year and a half. How much you're still going to be a high school dropout? What difference is it going to make? But the core argument has been if you're entirely withdrawn from the larger society, then you can have this right to withdraw from the education system. And many people have viewed Wisconsin versus Yoder as a case about no education after eighth grade. I think it's better viewed, I think the Supreme Court viewed it as a case about what we would now call homeschool. There's going to be continued education. Um, and and uh, and they'd gone through eighth grade, so they had the basics of reading and math and American history and so forth. It's not the education many of us would want for our children, but it wasn't true that there was no further education at home after that point. So the argument has been Yoder doesn't apply unless you're completely withdrawn.
Mm-hmm.
And very few groups are completely withdrawn. So that narrowed it very dramatically. Then there's another issue in the case about what Yoder means, and it's a little bit complicated to explain, but in 1990, in a case called Employment Division versus Smith, Justice Scalia pulled together 5 votes to say there is no right to exemption from laws that burden your religious exercise or even prohibited, and in that case, prohibited a worship service. No right to be exempt from a law that prohibits your worship service if that law is neutral and generally applicable. And he never defined what he meant by neutral and generally applicable, but the tone of the opinion suggested that nearly everything is neutral and generally applicable. And so there was a fear that this looked like a repealer of the free exercise clause. It hasn't worked out that way because of some subsequent decisions, but that's how the lower courts initially received it. The first 3 years, every free exercise claim was oozing under Smith. He only had 5 votes, and I think it's a reasonable inference. One of those 5 said, I'll go along with this, but you cannot overrule anything. So he couldn't overrule Yoder. What was he going to do with Yoder?
Mm-hmm.
Which created this, this huge exemption from what looked like a very fundamental state law that everyone has to go to school. And so he created this category, what he called hybrid rights, that Yoder was a hybrid of free exercise and parental rights.
Mm-hmm.
That made it different. And he had a couple other examples of things that he said were hybrid rights. For a variety of reasons, the hybrid rights concept never made any sense and not much has come of it, but that's what he said about Yoder. And so part of the argument in Mahmoud is Yoder relevant only when there's a hybrid right claim, or is Yoder also a freestanding free exercise case?
Mm-hmm.
And what the school board wants to say is Yoder is only about hybrid rights. It's not a free exercise decision. You don't really have a free exercise right here because they say your religion really hasn't been burdened. We can talk about that too if you want, but your religion hasn't really been burdened, so there's no free exercise right, and therefore there can't be a hybrid right with parental rights. And one of the things we tried to say in our brief is Yoder is not just about hybrid rights or even mostly about hybrid rights. It's mostly about free exercise.
Okay.
There was a free exercise right for the Amish to keep their kids out of public high school. And you have to take it seriously as a free exercise case, Supreme Court. And when you do that, there ought to be a free exercise right to keep your kid out of this very problematic instruction on religiously sensitive issues. So the argument about Yoder is partly it's only groups like the Amish, and partly is it this weird category of hybrid rights, or is it really a free exercise decision? And we think it clearly is a free exercise decision.
And the Fourth Circuit really kind of enthusiastically embraces the hybrid rights view of Yoder and really kind of shot down the parents on that basis, basically saying, well, you didn't show that your rights were burdened, therefore you have no Yoder type claim. Let me ask you this, Professor. There's a paragraph I'm reading now in the opening brief of the parents and Mahmoud. It says they say, okay, the Montgomery County Board responds that Smith forecloses relief under Yoder. That's Employment Division versus Smith, which you just mentioned. Forecloses relief under Yoder, and that any lack of general applicability and neutrality under Lukumi, and if you think you want to explain what that case is, please feel free, is not enough. Under the board's view, petitioners' right to direct their children's religious upbringing ends at the schoolhouse doors, with no limit on what their children may be taught within. But if that is what Smith allows, then Smith is in direct conflict with free exercise guarantees and should be overruled. So their brief here, I mean, they're arguing that Smith should be overruled. Do you think that there's a lot of kind of talk about Employment Division versus Smith being overruled in other this is something that people have been kind of clamoring for, and this is what the Religious Freedom Restoration Act was attempting to do via statute, which I think you had a lot to do with that statute as well, which is another story being that act. But do you think that this could be the case where the Supreme Court decides to overrule Smith?
Could be. I think probably not. I don't think they have to go that far. I mean, Smith has had this interesting history, in part because of how the issues coming to the court changed, in part because how the personnel in the court changed. So as Smith was actually a terribly written opinion. It was deeply ambiguous. And he had all these cases he couldn't overrule. And so there were all these parenthetical clauses that carved out exceptions, and he never said what he meant by neutral and generally applicable, and he wasn't very clear about any of the exceptions. So, I wrote an article at the time that said, if he's serious about the exceptions, then all this litigation will be a lot more complicated, but not that much will change. And if he's not serious about the exceptions, this is a formula for persecution. And the first 3 years in the lower courts, it was the formula for persecution, although the political reaction wasn't so bad. We did get some cases of actual persecution. We didn't get many, but all free exercise claims were losing. And then, the next case the Supreme Court took, Church of the Lukumi Babalu IA, this is an Afro-Caribbean group that sacrificed small animals to their gods. And the city of Hialeah banned it. And you could kill an animal for any imaginable reason in Florida and in Hialeah, except you couldn't sacrifice it to a god. So if there were ever a case of singling out one religion and saying we're going to make you illegal, this was it. And unanimously the Supreme Court, I mean, let me back up. It is revealing that, I actually argued Lukumi. We didn't get a single vote in the Court of Appeals. They thought this counted as neutral and generally applicable.
Right.
And we got it unanimously reversed in the Supreme Court. And Lukumi is also an ambiguous opinion. And government lawyers ever since have said it's only if it's as extreme as Lukumi. It's only if you were completely singled out. But that's not actually what the opinion says. What the opinion said is if you allow people to do something for secular reasons that undermines the government's asserted reason for restricting the religion, well, that's discrimination. You have to have a religious exemption too. And that has come to be a very powerful argument. And so now the conservative majority on the Supreme Court says if there's even one secular activity that's permitted to do this thing that the religious group isn't permitted to do, you got to have a compelling reason to justify that distinction. And in Fulton versus Philadelphia a few years ago, they said, if you reserve the right to make exceptions, even if you haven't made any yet, but you reserve discretion to make exceptions, government, then you have to have a religious exception. So part of the challenge for litigators ever since Smith is, do I argue this within Smith? I fit within one of the exceptions, so I win even under Smith, or do you argue they should overrule Smith? And you kind of have to choose, because you only get 15,000 words and they go fast. But by now, the exceptions to Smith are so well established and so stringent that I don't know if they'll ever have to actually overrule it.
Right.
And it hasn't been a central issue here, right? They didn't make it a big part of their brief.
Yeah.
It was a bigger part of the briefs in Fulton v. Philadelphia because there weren't any exceptions yet, and they didn't bite. Alito wrote, I think, what was intended to be the opinion of the court, and then he lost his majority. A 77-page concurrence about why Smith should be overruled.
Which case was that in?
Fulton versus City of Philadelphia.
Oh, yeah.
It was about Catholic charities and its adoption agency, and did they have, and because they wouldn't serve gay couples, city refused to deal with them at all.
Sure.
There were no real gay couples in the case. They'd never been approached by a gay couple. They never turned anybody away. But somehow it had come out that if there ever were a gay couple, they would say, look, we can't place a child with you. So Alito had 3 votes to overrule Smith, and then Barrett and Kavanaugh wrote an opinion that said Smith is probably wrong. No other First Amendment right is only a protection against discrimination.
Right.
But we don't have to overrule it to decide this case, and we're not sure what we should replace it with. So until Barrett and Kavanaugh answer that question for themselves, it's probably not going to get overruled.
Yeah, I was just going to read there's a really interesting passage in Fulton in Alito's concurrence. He says, as interpreted in Smith, the free exercise clause is essentially an anti-discrimination provision. It means that the federal government and the states cannot restrict conduct that constitutes a religious practice for some people unless it imposes the same restriction on everyone else who engages in the same conduct. And it's interesting that that Smith seems to have really, I don't think the founding fathers would have recognized their work as being essentially, merely an anti-discrimination provision.
Well, that's another subject that's been much debated, and I think in some ways it's the wrong question.
Okay.
The founders didn't face the issue we do because there was much less religious diversity and there was much less government regulation, and so the issue and judicial review was not yet well established with a long tradition. So the issues that came up where people needed religious exemptions were handled legislatively, and they nearly all got them. Right.
Okay.
What did religious liberty mean to the founders? Seems to me it meant, the Quakers didn't have to serve in the militia. They didn't have to swear oaths. They didn't have to remove their hats in court. The Baptists could preach without a license, and dissenters from the established church didn't have to pay the church tax. And there wasn't much litigation. There was a little bit, and it went both ways. In part, it went both ways because some judges said there shouldn't be a judicial review. We don't have power to hold anything unconstitutional, so we don't hold this unconstitutional either. But so they protected the practice of religion. They protected conduct that was religiously motivated, protected that from government regulation. But they thought about it one issue at a time. There's very little discussion of whether there's a general right to religious exemptions in the free exercise clause. And because there was so little discussion of it, historians and law professors can go back and scrape together the little bit of evidence there is and come to opposing conclusions.
Yeah. Well, you mentioned actually an interesting point about the expansion of government generally, and it's certainly the federal government, but also state governments, and this just creates a very different set of circumstances. So it's difficult to understand how. I mean, let's say it's not always obvious how uh, the general principles that were articulated by the founders apply in this, in these, these different contexts. One of those is schools, for example. I mean, with compulsory schooling, um, when this sort of wave swept the United States in the 1800s, at that time, most people were farmers, and compulsory schooling really got in the way of people attempting to, parents who thought that their kids would be better served, working in the fields than going to school. And now, in our day and age, most people are not farmers, and um, most of the objections that people have, to the extent that they have objections, are going to really be based on religion, as opposed to some other kind of, reasons why compulsory schooling originated in the first place. So I wanted to ask you, do you think that there's something inherently kind of uh, incompatible, or constitutionally incompatible about compulsory schooling itself? Because there seems to be this notion that, you know, the government has a right or has an interest in requiring that children um, adopt. These are some of the interests that were cited even in the early 19th century. That children learn citizenship. They learn how to become good citizens. They learn how that they learn English. Because many of the uh, children at the time spoke German because they were first generation immigrants, or Polish or something like that, but there's a kind of nation building there as well. And then there were other issues like, wanting kids to, wanting to get Catholic, to sort of Catholic or Lutheran kids out of their insularity. And then, you see this kind of replicated in New York with Orthodox Jewish parents. Is there a kind of inherent clash between this idea of, everyone has to send their kids to school so that we can kind of homogenize to some degree, not thoroughly and not entirely, because there's kind of, it's not a full on kind of homogenization that's aimed at, but at least some degree of kind of nation building there. Is there an inherent conflict there with free exercise and or um, the right of parents to dictate the upbringing of their children?
There's some conflict. I think to some extent it's been exaggerated by both sides, but especially by the school board side. The principal protection against homogenization has been the right to send your kid to private school. But of course, that only works if you got enough money to do that.
I'll ask you to elaborate on that point in a little bit, but yeah, go on.
I think clearly the state has a compelling interest in insisting on the basics of education.
Sure.
You got a right to control the education of your child. You don't have a right to keep him illiterate or illiterate, right? State can insist that everybody learn English, everybody learn to read and write, everybody learn to do basic math. And I think everyone learn the basics of our system of government and the duties of citizenship, including, as a matter of law, we have to treat everybody equally, even if you disapprove of how they're living their lives.
Mm-hmm.
Don't think we have any right or there's any strong government interest in saying you have to approve of what they're doing, right? Which is what Montgomery County is trying to do. Now, in these cases about opting out of parts of the curriculum that we've talked about, the school boards have absolutely refused to draw any distinctions between what they have a compelling interest in insisting everyone learn, like reading and writing, and what might be more optional, right? They say once you're in public school, we have a compelling interest in insisting you learn whatever we choose to teach you. And that's been taken to extraordinarily extreme degrees. So this Tennessee case back in the 80s, you know, 3 judges on the Court of Appeals, 3 different opinions, all ruling against the families. And one of them said, there are no limits. The school can teach anything it wants, and you have to study it as long as it's not prohibited by the Establishment Clause. So they can't teach your religion, but they can teach things that are inconsistent with your religion. And then there's a First Circuit case called Hot, Sexy, and Safer about a guest speaker at a high school assembly who was doing things like blowing up a giant condom and putting it on a student's head, asking another student to show his orgasm face. And the school said, or the Court of Appeals said, no problem, no violation, no right to opt out. So, that's a very long ways from insisting you learn how to read and write for the system of government. So there have really been no limits, and that's where the conflict comes from, right? So there are limits on how far we can go with homogenization, but there are things that the government has a compelling interest in insisting everyone learn. And school boards have successfully resisted addressing that question. They've gotten away so far with saying, we've got a compelling interest in everything. I don't think that's going to work in Mahmoud v. Taylor, but we'll see.
You make a very good point, because throughout this case, and I had a conversation with a Montgomery County city council member who said, and this was at one of the school board hearings. She told me, well, look, if parents can opt their kids out of this, then they're going to be able to opt their kids out of teaching evolution, and they'll be able to opt their kids out of teaching about interracial marriage and so on. And I said, I was trying to explain why, in my view, this was different, but at the same time, perhaps it is different at a more granular level, but maybe like at a higher level abstraction, it's not much different. And on the other hand, one can see the slippery slope in the other direction, that if parents can never opt out, then schools can teach literally anything, and your kids have to sit there and absorb it if they're going to public schools. So is this one of these kind of things, or it's just kind of a line drawing? Is the court going to have to say, well, they can opt out of this, but they can't opt out of evolution. They can opt out of, is this a line drawing thing based on just sort of the empirical facts of the case?
Yeah, pretty much. And it needs to be based on a theory of what's essential to public education. I actually think parents should have a right to opt out of evolution. But I also think school board ought to be able to say, you can opt out of evolution, but it's the basic organizing principle of biology. So we will not put on your transcript that you passed biology.
Yeah.
If you want to take the rest of the biology course for your own benefit and opt out of evolution, you can do that, but you're not going to get credit for biology. Because there really is not a compelling interest to everyone understand evolution. And if you ask most adults to explain it, you would get mush. It's not that everyone has learned it. And it's certainly not that everyone believes it. So, the number of things that we really have a compelling interest in insisting everyone learn is a pretty short list, in my view.
Right.
The number of things that draw many requests to opt out is also a pretty short list. And there'll be idiosyncratic people from time to time with some weird objection.
Yeah, flat Earth or something like that.
Yeah, but mostly we know what the objections are going to be to, and we can figure out how to deal with them. And unless you are willing to engage in that discussion, what's truly essential for everybody and what isn't, then you get this choice between two extremes. Any parent can opt out of anything, or we can have hot, safer, and sexy assemblies every week, right?
Do you, given that there is kind of a commonsensical, um, perhaps approach to resolving this case, do you think that there will be, well, first, what do you think the outcome is going to be? And second, do you think that there will, just in terms of the, are they going to win or lose, the parents here, but also, how far do you think the court is going to go in resolving some of these loose ends that we've discussed, ambiguities in the law? And finally, do you think that that there will be kind of conservatives on one side, liberals all dissenting, or do you think this is one of those cases where there's enough of a sort of common sense middle ground that there'll be more a larger majority here?
I don't think they'll go much further than they have to.
Mhm.
This highly sexually sensitive content is subject to opt out for religious objectors. They're not going to decide anything about evolution for sure.
Yeah,
They're not going to announce a general right to opt out. I don't think.
yeah.
If they do, they will for sure get 3 liberal dissents. If it's more constrained, I'm not so sure. They might pick up Kagan's vote.
Mm.
Sotomayor is harder to reach in these cases. Jackson, I think we just don't know enough about yet. But I would not be astonished by a fairly narrow unanimous opinion.
I see. Oh, wow.
But I wouldn't be surprised by 3 liberal dissents either.
Yeah. I was talking with some folks on the I'm on can't I'm not going to hide it. I'm on the side of the parents in this case, but have been working with them on the ground from the beginning. But I was talking with someone on the other side who said that they actually went, and I'm not going to mention the name of who they did, but very well-known legal scholar who's in a same-sex marriage and constitutional scholar, and they went to him and they said, we'd like to get your help in in support, in going against the parents in this case. And he told us, he said that he personally has advised Montgomery County Board of Education to grant the opt-out. you know, so and so it just seems that, yes, there is a very vocal minority of folks who really think that Montgomery County needs to hold the line here. And then there's kind of, most other folks who think that they've kind of gone past the bounds here. I'm just a little surprised that the Fourth Circuit didn't find any harm here. Was this sort of them attempting to kick the can down the road a little bit, or kind of I think I think it was Alito who in a dissent from denial of cert, in a similar case out of the from the Seventh Circuit, he accused the courts below of attempting to avoid their Article 3 duties by citing things like finding people had no standing because they couldn't identify a harm, and in this case it's kind of similar, but it's in the context of a TRO saying they hadn't shown the harm. You kind of criticize them for saying you guys are avoiding adjudicating really important constitutional issues, and you're finding kind of loopholes around it. Is that kind of what you think might have happened with the Fourth Circuit here?
Well, Alito's a fine one to talk, right? The conservatives all want to get rid of establishment clause cases on the ground there's no standing. But no, the issue you identify runs deeper than that. Through all these cases about opting out of parts of the curriculum, the school boards have always said, and often the lower courts have said, there is no burden on your exercise of religion unless they require you to believe what they're teaching. But being exposed to something you disagree with is not a burden on your religion. And, for many people, that's true, right? There's a lot of value in being exposed to ideas you disagree with. Uh,
Hmm.
and I'm sure there are plenty of parents in Montgomery County who aren't entirely happy with these books, but haven't asked for an opt-out, right? Um, but there have always been people for whom um, reading stuff that undermines your religious faith is prohibited, right? That's why the Catholic Church had an index of prohibited books for decades and decades. Uh, it's why you know, Catholics are more centralized. They have more terms of art to describe some of these ideas, but other
Hmm.
faiths have quite similar ideas. Um, Doing some things are a near occasion of sin. It's not a sin in itself, but it leads you into, or it tempts you, or and then when you look at the age of these kids, um, the parent-child relationship makes all of that worse, right? And the parent may well say, "I could read this stuff, but I don't want my kids reading it with me not around there, um, because
Right.
it leads them into false beliefs. It leads them into moving away from their faith or what I hope to instill in them as their faith. Um, and so the mere reading of it is prohibited, or the mere permitting my kids to read it without the right kind of supervision is prohibited. And and what the Fourth Circuit said is, no, none of that is a burden on your religion. It's only a burden if they're coerced to believe what they're reading. And that's been a common refrain in these lower court cases.
Oh, well, so we might see a clarification on that from the
I
court
think
and
we
the
will. I think we will.
uh,
Because they can't really decide the free exercise issue in favor of the parents without finding a burden on the religion. And the burden they're going to find is um, your kids being exposed to material that lures them away or tries to persuade them away. Lures isn't the right word. So
mhm.
clearly trying to persuade them here, persuade the kids that what their parents are teaching is wrong and what the school is teaching is right. That's the burden on religion here.
Wow, that's yeah, that seems to be the core issue then. The last thing I'll mention, you touched on this that um, there's this notion that well, if you choose to send your kids to public school, then you have thereby opted in to everything that they are going to be exposed to. Now, um, again in 303 creative, I'm going back to that. I'm just remembering that, yeah, there was also this argument that, well, if you choose to enter the marketplace and open up a business, then you have to accept what comes along with that. Isn't there a sense in which, this is sort of a Hobson's choice? I mean, for many parents don't have the finances to send their kids to a private school. Many kids don't have private schools. Many parents can't homeschool their kids, so they have really no choice. And I can tell you empirically, I mean, that I know these families, and many of these families are very poor, or at least, poor enough that they can't afford to send their kids to private schools. So is this also, do you think that this also comes into play in this case?
Well, I think it does. Yeah, and the private school network is an important protection, but it only works for people who can afford it.
Yeah,
And um, and there's strong policy arguments for not diverting more money to subsidize private schools, and there are arguments to be better for individual freedom if we did subsidize private schools. Um, and I don't have any expertise in the educational policy arguments, so I stay away from that issue. Uh,
yeah,
but but clearly in the system we have, um, the state requires people to attend school, and there's only one free school available to them. And so, in effect, most of the population is required to attend the public school. And
yeah.
they didn't opt in. It was, um, they were coerced in.
Yeah. Well, thank you so much. On that note, I just want to express our deep gratitude for your time and your insights and your wisdom, and for that matter, for your entire career and body of work, which has really served to uphold, the freedoms that we all hold dear. And so, for that, I want to thank you personally very much for your work. And yeah, any final closing words on this one? Anything we should be watching out for in oral arguments?
I think we pretty much covered it.
Okay, thank you, sir, and hope to meet you in person one day.
You're very welcome.
God bless you.